Good morning, sir. Are you Argelio Arilano?
Yes, good morning. Me contesta en español. ¿Es usted Argelio Arilano? Sí. Yes.
And will your client waive the formal reading of the indictment?
He will.
Mr. Arilano, in cause number 21-38292, you're charged with a third-degree felony offense of smuggling of persons from July 28th of 2021. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yeah. Yes.
Do you fully understand them?
More or less.
Well, let's go through it. Do you understand that if I follow the agreement that you made with the district attorney, that you will not be able to change your mind or appeal your case?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
Is there anything else that you don't understand that you want to ask me about?
Well, that's all.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Arilano is not competent?
Oh, yeah.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of smuggling of persons. Sentence you in accordance with that agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish. Please read it carefully, because possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right, good luck to you, sir. You can go back with the bailiff. Thank you, Mr. Rojas.
Thank you, Judge.
Hey, sir, you Travis Cormier?
Yeah.
And this is cause numbers 25 DCCR 1448 and 1449. Mr. Cormier is charged in each of those cases with assault on a security officer. Mr. Cormier was evaluated for competency to stand trial by Dr. Hamza. I've received that report, which is dated February 9th of 2026. The finding in his report is that Mr. Cormier is currently not competent to stand trial, and that inpatient treatment for competency restoration would be necessary. Is there any other evidence with regard to competency?
Not from the finished judge. Not from the state judge.
All right, then at this time in each of the cases, I am going to find Mr. Cormier not competent to stand trial based on that report. I am going to order that Mr. Cormier go to the appropriate facility for competency restoration for a period of not to exceed 120 days from the date that he gets to that facility, and then we will await their report with regard to competency restoration. I'm not sure which one it'll be, but you'll go to a hospital so that you can get whatever you need so that you can. I'm not sure. It might be not Fannin probably. It's going to be somewhere else. And
Is it today?
it'll be soon. All right. So you're going to have to wait in the jail until they have a bed for you. It might be a little while.
Oh, okay.
Then they'll send you. So if you're in jail and there's medication that they're trying to
I'm
get,
already on my meds.
make sure you take all your meds, because if you get better and feel like you understand things, we
I
might
got
take
time
care
to
of it.
serve for the rest.
No, we're not taking care of anything right now other than getting you where you understand everything. Okay.
Okay.
All right. You can go back with the bailiff.
All right. Hey,
Good morning. Are you Sebastian Cepeda?
this month.
And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Cepeda, in cause number 25 DCCR 0310, you're charged with the state jail felony offense of theft from a person, and that's from February 5th of 2025. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, you go over them with Mr. Lewis.
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Cepeda is not competent?
No, Judge, there is to competency, but I was made aware after speaking with his mother that there is some mental health issues where he has not done his medication.
Okay,
So as far as any.
we'll make that part of probation. Okay. Is there any restitution?
Judge, we sent our standard, the short answer is no. We got our standard restitution letter and we did not receive a response back.
Okay. Any reason not to waive the pre-sentence report? Do you anticipate that there would be based on the facts? Let me look at this.
Well, Judge, the allegations are that this defendant was in the process of a theft from a vape store, and in the process he pulled the clerk. Yeah, it's not that egregious.
I'm just saying, but they didn't, nothing was actually taken, so there wouldn't be
There would be
restitution. So no reason, no history to speak of that I need to be
Just some
concerned about.
juvenile history, Judge. He does have a couple of pending cases in Refugio County, but as far as I know, they haven't been adjudicated.
Okay. And then, Mr. Cepeda, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, at this time, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That's going to include following any treatment and recommendations for any type of mental health issues that you have. If that means going to Spinal Tap or a doctor or wherever you live, something similar to that. If they recommend that there's medication you're supposed to be on, then you will be required to take that now as a condition of probation. Follow through with any counseling and all of that so that you'll be successful in probation. Do you understand?
Yes, ma'am.
It looks like it's trying, but I'm going to hand you in just a minute the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you today before you leave the courtroom and give you some documents so that you know when you're released that to go straight to the probation department so they can get you started and everything you need. Okay.
Yes, ma'am.
All right. Good luck to you, sir. Here's that. Oops, sorry. Good morning. Are you Paul Jackson? And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we are.
Mr. Jackson, in clause number 26 DCCR 0112, you're charged with the first degree felony offense of aggravated robbery. And that's from January 5th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yeah.
So I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. It shows me that there is no agreement in your case and that you're leaving your punishment up to the court. Is that correct? So you're wanting probation. The state is asking me to send you to prison. It'll all be decided when we come back here later. And I look at the underlying offense. I look at any evidence that your attorney brings me, anything that the state brings me, and then I can decide to sentence you anywhere in the range of punishment, which is from probation up to between 5 years and up to life in prison. Do you understand? Do you understand?
Yes.
And there's no agreement, which means you would have some rights to appeal depending on how that goes and what I do. Do you understand that as well?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. I also want to make sure, Mr. Jackson, that you understand you have an absolute right to have a jury come in and determine 2 things. You can have the jury determine if you're guilty or not, and then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? So you can either do what you're doing today, that you've signed on the paperwork and leave your punishment up to me, or you can go to a trial and let a jury decide. Okay. Is there any evidence that Mr. Jackson's not competent?
No, Your Honor.
All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
This is where the courtroom dynamic changes completely. Unlike the earlier defendants who accepted plea deals, this man is rejecting the prosecutor's offer and preparing for trial. The judge is about to explain how a prior felony conviction could significantly increase the possible sentence. That's a crucial legal moment because one past conviction can dramatically raise the stakes. What would you do in this situation? Take the deal or take your chances with a jury?
Good morning, sir. Are you Clifton Alton Keller?
Yes, ma'am.
This is 25 DCCR 1462. And Mr. Keller, you're charged in that case with the second-degree felony offense of arson from July 15th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, November 17th of 2008. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be enhanced to that of a first-degree felony if that prior conviction's true, which means your minimum punishment would be 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 15-year term in prison. You have every right to reject that and go to trial and have a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Absolutely.
And you want to reject that offer and have your case set for trial.
Yes, ma'am.
And is there any reason to believe that that offer would change?
No, Your Honor.
So I just want to make sure you understand, Mr. Keller, that once you're on the trial docket, your case will be expected to either go to trial, or if you change your mind and you want to enter a plea of guilty, it would be open to the court or some different plea agreement. Do you understand?
Yes, ma'am.
All right, then we'll get your case set for trial. Mr. Keller, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles several cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
So you want to get rid of Mr. Lewis?
It's up to you. You
No.
can keep Mr. Lewis or you can get another attorney.
No, ma'am.
All right, so Mr. Lewis will begin preparation for trial. All right, you can go back with the bailiff.
What makes this ending so fascinating is that the defendant knowingly turns down a 15-year prison offer and chooses the uncertainty of trial. That's a high-risk decision because a conviction could lead to a much harsher sentence. We saw several different outcomes in this courtroom today, but this case leaves the biggest question unanswered. Did he make a smart move or a costly mistake?